It's Elias Jiryis with Remax Twin City in Kitchener-Waterloo, and I'm breaking down Ontario's new legislation, Bill 60, and what it means for both landlords and tenants. This video is for you if you own a rental property, you're thinking about investing, or you're currently renting and want to understand your rights and risks under the new law. So what is Bill 60? Bill 60 is a new Ontario law that makes several changes to the Residential Tenancies Act and to the way the Landlord and Tenant Board operates. The stated goal is to speed up decisions, reduce delays at the Landlord and Tenant Board, and address issues around unpaid rent and the housing crisis. However, the bill is controversial because many tenant advocates say it will make evictions easier and weaken protections for renters, especially those who are already vulnerable. In this video, I will not take sides. Instead, I will focus on what is changing in practical terms and how it may affect you on either side of the rental agreement. The first major change in Bill 60 is the notice period for unpaid rent. Under the previous rules, if a tenant did not pay rent on the due date, the landlord could serve an in-for notice, and that notice had to give at least 14 days before the landlord could apply to the Landlord and Tenant Board to evict for non-payment. Under Bill 60, that timeline is now shorter. The in-for notice for non-payment can now set a termination date that is only 7 days after the notice is given. In simple terms, tenants now have half the time to fix the problem before an eviction application can be filed. So for landlords, this means less time carrying a non-paying tenant before being allowed to move forward with the legal process. So for tenants, it means there is less room for delay. If you fall behind on rent, you will need to act very quickly within days, not weeks, to avoid an eviction application. The second major area involves persistent late payment of rent. Bill 60 gives more structure to how persistent late payment can be handled. The government now has the ability to define through regulation what counts as persistent late payment and to use that definition when landlords apply to end a tenancy. For landlords, this may create a clearer route to remove tenants who pay late month after month, even if they eventually catch up. For tenants, this means that always being a few days late could become a bigger risk. A pattern of late payment may, depending on the regulation, be used as grounds to end the tenancy, not just a one-time missed rent. The key takeaway here is that consistency matters. Regular on-time payments are now more important than ever. A third major set of changes affects how tenants can defend themselves once an eviction application is at the Landlord and Tenant Board. Previously, tenants had fairly wide flexibility to raise issues such as repairs, maintenance problems, or other landlord breaches as part of their defense during hearing, even if those issues were not raised earlier. Under Bill 60, the ability to do so is being narrowed. Tenants who want to raise these kind of issues may have to meet stricter requirements and in some cases may need to pay a portion of the rent arrears claimed in order to rely on that defense. In addition, the rules for asking the board to review its own decision are more strict. There is a clear short deadline to request a review, and the board's power to change its own orders is more limited. Finally, the Landlord and Tenant Board's general power to refuse or delay an eviction in the interest of justice is now subject to new limits and regulations. That means there may be fewer situations where an adjudicator can simply decide that an eviction would be unfair and refuse it, even when rent is owed. For landlords, these changes may result in fewer surprises at the hearing and in more predictable outcomes when rent has not been paid. For tenants, it means it is more difficult to rely on last-minute arguments or issues, and there may be fewer second chances once the process is underway. Another important area involves no-fault evictions. These are situations where the landlord is not alleging bad behavior but wants to end the tenancy because they or a family member will move in, or because the property will be demolished, converted, or substantially renovated. Under Bill 60, some of the rules around compensation in these situations are being adjusted. In certain cases, the amount of compensation that a landlord must pay a tenant when ending a tenancy for these reasons may be reduced, depending on the exact circumstances and the regulations that apply. For landlords, this may lower the cost of legitimately taking back a property for personal use or for a major work. For tenants, it can mean less financial support when they are forced to move in a very expensive rental market, making the transition more difficult. It is also important to clarify that what has not changed. There was earlier discussion about possible changes to month-to-month tenancy, sometimes called evergreen leases, where a fixed-term lease automatically continues on a month-to-month basis if neither party signs a new term. At this time, those changes are not moving forward. This means that the basic rule still applies. When a fixed-term lease ends, it normally converts to a month-to-month tenancy under the Residential Tenancies Act, unless the parties sign a new agreement. Rent control rules also remain in place under the existing framework, including the usual exemptions that were already there before Bill 60. Now, what does this mean for each side? If you are a landlord, Bill 60 generally strengthens your position when it comes to non-payment of rent and persistent late payment. You can now move quickly when rent is not paid, and you may face fewer procedural obstacles at the Landlord and Tenant Board when the arrears are clear. However, this does not replace the need for good documentation and proper process. You still must use the correct official forms, give proper notice with accurate dates, keep clear records of communication and payment, and when in doubt, get legal advice or consult a licensed paralegal. It is also worth remembering that strong investment depends not just on the law, but on the relationship. Clear communication, fair expectations, and proactive problem solving with your tenant can prevent many disputes from ever becoming legal cases. For tenants, Bill 60 increases both the speed and the seriousness of the process around rent and eviction. If you're renting, paying on time is more critical than ever. If something goes wrong, you lose a job, your hours are cut, or a personal crisis hits, you need to act quickly. Do not ignore notices. If you receive an N4 or any other LTB form, read it carefully, respond immediately. Seek help from community legal clinics, tenant organizations, or lawyer, or even a paralegal, because timelines are shorter and defenses are more restricted. Waiting even a few days can now be the difference between resolving an issue and facing an eviction order. Here in Kitchener-Waterloo, changes like Bill 60 will have real impact on local landlords and tenants, from small investors with one basement unit to families renting their first home in Canada. My role as a real estate professional is to help people understand not just prices and interest rates, but also the rules that shape our housing market. If you are a landlord with questions about how these changes might affect your investment and its value, feel free to reach out. I cannot provide legal advice, but I can connect you with the resources and help you understand the big pictures so you can make informed decisions. If you found this video helpful, please like the video, subscribe to the channel, and share it with anyone you know who owns or rents in Ontario. This is information they need to hear and understand. Thank you for watching. I'm Elias Jiryis with RE/MAX Twin Cities, serving Kitchener-Waterloo, and I will see you in the next video.